Good evening, everyone. My name is Rosalind. I'm the Reentry and Partnership Coordinator for BARD Business. And on behalf of Justice Reform Partnership, I would like to welcome you all to our Talk Justice Tuesday post crossover legislation review webinar. Thank you all for coming this evening. We are excited to have you with us. Our coalition, the Justice Reform Partnership, or the JRP, has grown from 5 organizations to over 90 organizations and individuals working to advance meaningful criminal and juvenile justice reforms across Georgia. Our coalition brings together grassroots organizations, community organizers, advocates, directly impacted individuals, and policy experts, all committed to build a more just and equitable system for our state. Talk Justice Tuesday is our annual series, which is focused on legislative and policy changes capital that directly affect communities impacted by the criminal legal system. This series here is designed to break down complex policy issues for the public, amplify the voices of directly impacted communities, and to identify actionable strategies for advocacy. So during tonight's session, we'll get a much better understanding of what has moved forward over crossover day, what has also stalled, and what comes next in key effective advocacy in these final weeks of the legislative session. So before we begin tonight's legislation review, we're going to cover a lot of important updates from multiple panelists. If you have any questions at all, we ask that you go ahead and drop them in the chat. Any questions at all, we welcome. We want to have a good communicating Q&A at the end of our session. We will have time, so please make sure that you drop any questions. We'll also have you join us for our final Talk Justice session, which is on April 8th. We hope that you will join us. That legislation session is called Avoiding Burnout, Surviving and Thriving in Advocacy. And again, that date is on April 8th. This has been a very tough legislation session, and we want to hold space for reflection, community, and also for self-care when we close out. So for more information for any future events, we want you to make sure you check the chat for the links to our website and also ways to stay connected. We'll also be sharing tonight's presentation, the materials and resources with all of you afterwards, so you all will have a copy. All right, let's get started. I want to, and I'm very, very fortunate and pleased to announce and introduce Blake Philman, who is our Senior Policy Counsel at the Southern Center for Human Rights. Blake will be facilitating tonight's post-crossover day review panel, and he will also be introducing any other panelists. Blake?
Thank you, Rosalind, and thank you everyone who made time to join us after 5 p.m. when everybody's tired. But this is important stuff, so I'm glad that you're here. First of all, just what is crossover day, which happened last week. It was on March 6th. During the legislative session, a bill has to pass from the chamber in which it was introduced to the other one. So for it to be passed by the other chamber and signed into law this year. So only House bills that made it to the Senate by the evening of March 6th, and Senate bills that passed the Senate and moved to the House by that date are in play. So first, we're going to talk to, and by we, I mean mostly everyone else, is going to discuss a lot of the good bills that made it past crossover and are still in play. After that, we'll talk about some of the bad bills that are still in play because they crossed over by March 6th. And then finally, we are still going to talk about some of the bills that didn't cross over, because sometimes, even though a bill doesn't survive crossover day, legislators can sneak the content of that bill into a bill that did cross over through amendments and substitutions. So, and before we get started, I am just going to ask everyone on the panel if you can just introduce yourself, your name, pronouns, and organization. And we'll start with Coco.
Thanks, Blake. Good evening, everyone. I'm Coco Guthrie-Pappy. I'm the Director of Public Policy and Communications at Deep Center, which is a nonprofit based in Savannah, Georgia, and I use she, they pronouns. And I'll pass it to Wade.
Thanks, Coco. Hi, everyone. I'm Wade Askew. I use he, him pronouns, and I'm the Policy Director at Georgia Justice Project, and I will kick it over to Ray.
Thanks, Wade. I'm Ray Calfani, he, him pronouns. I'm a senior analyst for workplace justice and criminal legal systems at Georgia Budget and Policy Institute. Pleasure to be here. I'll pass it over to Graham.
Hi, everyone. My name is Graham Younger, the policy advocate for GACTL, the Georgia Association of Criminal Defense Lawyers, and I don't think I have anyone left to throw it to.
Cool. Thanks, y'all. And I forgot to mention the last section, which will be, we will address your questions that you put into the chat. So please do that if you come up with questions throughout the entire event, and we'll try to get to those at the end. So first, we're going to discuss some of the good bills that we support that survived crossover. And I'm going to go first. And then literally for the rest of the presentation, everybody else is going to do the talking. But we at Southern Center are excited that House Bill 123 survived crossover. It's now in the Senate. Again, and we discussed it at Justice Day. We discussed a lot of these bills at Justice Day, but House Bill 123 makes two important changes to Georgia law regarding the determination of intellectual disability in capital cases. Georgia is the only state in the country that forces people to prove intellectual disability beyond a reasonable doubt to avoid execution. So the first thing that House Bill 123 does is it changes the standard to preponderance of the evidence. Georgia is also the only state that asks the jury to decide guilt and intellectual disability at the same time. So the second and just as important thing that HB 123 does is it separates the determination of intellectual disability from the determination of guilt. Like I said, it passed the House before crossover. It's been referred to Senate Judiciary, where it could be taken up for a committee hearing any day now. So supporting it as it makes its way through the Senate will be very important. As of right now, it's halfway to the finish line. And to discuss another bill that survived, I'll pass it to Coco.
Thanks, Blake. Yeah, I'm here to talk about a good bill, HB 79. I just want to preface with that, working within the Georgia legislature, we remember that good is not the enemy of perfect, quite often. And so this bill is really, it's a good bill. It's a great start. It's also primarily a tax bill, right? And so why are we talking about a tax bill when we're really doing criminal justice reform? So you might know it as the Safe Storage Act. Its official name is the Firearms Safe Handling and Secure Storage Tax Credit Act. It's a mouthful. But it basically aims to incentivize responsible firearm ownership by offering tax credits for safety-related expenses or firearm secure storage, right? It's a $300 one-time tax credit. There's a total aggregate annual cap for all taxpayers at 10 million. So what that just means is that if enough people file for this one-time tax credit, once it hits 10 million, the program will stop. and or it will sunset in 2026, right? So it does have some limitations insofar of its lifetime. And so really, like, the bill's financial scope is controlled through that. And the question is whether it remains to see whether it's like the incentive is sufficient enough to encourage widespread participation. But insofar as like an attempt towards meaningful firearm safety reform in the state of Georgia, it's a really great first step, right? And it's really based out of a reaction from the Appalachia High School shooting that happened last year that I think many of us have been impacted by. And so if you're interested in sort of pushing it forward, having conversations with legislators, it's currently in the Senate Finance Committee, and that is chaired by Chairman Chuck Hefstetler. I always get his name wrong. And again, I think some really great talking points that like we love safe storage. We passed a really similar ordinance down here in Savannah, Georgia, through our city council, and it's proven effective with our community. And so seeing this introduced at the state level is thumbs up from us, and I will cap it there.
Thanks, Coco. And next, I'll pass it to Wade, who has a few bills that he wants to talk about.
Yeah, thanks, Blake. Grateful again to be here. So at Georgia Justice Project, through the great work of a lot of different people in coalition and also through a lot of luck, we had all four of the bills that we're championing crossover this year. So I'll kind of do a quick lightning round on these. And I'll, after speaking, kind of put in the chat where you can find more information about these bills and or sign up for action alerts. But just going very quickly, the first HB 162, that is our bill that would ensure that if an individual is sentenced under the First Offender Act, which is a act, it's a part of our criminal code that's been around since 1968, that if you're sentenced under that particular section, that records of that case would be sealed at sentencing and would remain sealed as long as you are successful with your First Offender Act sentence, which accounts for about 97 to 98% of cases. The grand majority of people who receive that type of sentence are successful with their sentence. And when they're successful, it's a non-conviction. So it is what you call discharged. So there's no conviction that ever happens. That is a pretty significant change of where things are at right now. And our argument has been the whole point of this act is to have someone who's accused of a felony offense for the first time, who's never been convicted of a felony before, should be able to not have this record be, a scarlet letter and prevent them from finding stability in housing, employment, et cetera. That's the whole point of the act. But if those records are public, that goal is severely frustrated. And so that passed unanimously out of the House, and now we're going to be heading to the Senate Judiciary Committee. Second is HB 582. The first thing I'll note, this is called the Survivor Justice Act. We are part of a broader group working on this. First and most importantly is there are survivors of domestic violence, largely who are currently in prison, who have been working on this issue for 10, 15 years. So we are grateful to be part of the work of so many who came before us, and part of a coalition with folks like really in the lead, the Georgia Coalition Against Domestic Violence, as well as Women on the Rise, Igniting Hope, YWCA, many others are involved in this effort. What HB 582 would do is, at a high level, it seeks to prevent convictions if a survivor has taken actions related to their own survival. And while they are facing either domestic violence, child abuse, family violence as defined by Georgia law. In addition to that, it would also say if someone in this situation does still end up with a conviction, that the actual sentencing range for that conviction should be different than it would be otherwise. It should be mitigated. So there is a portion of the bill that essentially would cut the max sentence in half if you are able to demonstrate that your survival of domestic violence, child abuse, family violence, if that was a significant contributing factor to what you have been convicted with. And then that would also apply to folks who are currently in prison. So there would be a mechanism to let people petition to get back into court and say DV was a significant contributing factor to what transpired, what led to this conviction. And so my sentence should be cut in half and then hopefully bring people home. So that passed out of the House. We're on to, again, the Senate Judiciary Committee, and we'll continue plugging away at that. Next is SB 207. SB 207, many of you may have heard us talk about SB 157 the last 2 years. SB 207 is the new version of that bill. So what it is a big bill. It primarily deals with occupational licensing. So 1 in 4 of high demand jobs in the state of Georgia requires an occupational license to work that job. We find that about 1 in 5, 1 in 6 clients at GJP is interested in or currently pursuing or in a licensed career. When you apply to get a license to work these kind of jobs, part of that process includes a background check into arrest and conviction history. What we're trying to do is say that that portion of the evaluation of someone's being able to hold a license in a certain field should, first of all, be transparent. Someone shouldn't have to go through all their education, all their training, and then only find out at the last minute after all this investment, I've been told no because of something that happened years ago. So we want people to have transparency to upfront say, I'm interested in becoming a nurse, or I'm interested in becoming a plumber, or I'm interested, whatever the career is. Here's my arrest and conviction history. Let's evaluate that and give me the green light to move forward and make this investment in confidence. Secondly, we want to ensure that boards and agencies are only considering things that are recent, serious, and related to the actual profession. So if I want to be an accountant and I've was convicted of writing a bunch of bad checks in the last year, okay, they're probably going to consider that. But if I'm applying to be an accountant and I have a DUI from 6 years ago, why is that relevant to my ability to be an accountant? So we're trying to really focus the evaluation of what boards are actually looking at. In addition, in SB 207, there are several provisions about record restriction. So kind of modestly expanding and making work better our record restriction law. So again, there's a lot of stuff in there. Senate unanimously passed it. We're on to the Judiciary Non-Civil Committee in the House, where we actually will be in front of a subcommittee tomorrow at, I think, 2 o'clock. Finally, very briefly, just going to touch on HB 535. So SB 207 is about 95 pages. HB 535 is about 5 lines. So opposite ends of the pole. But HB 535 is correcting a Court of Appeals decision that has created issues with people facing probation revocation hearings and probation revocations, serving a longer time in jail and prison than judges even intended. So without getting to weeds, it essentially fixes how time served is counted. When people sit in jail waiting to have a case adjudicated, if they're ultimately convicted of an offense, then they are credited with the time served sitting in jail. That applies in all contexts except for probation revocation hearings. So we're trying to bring some consistency there so people aren't serving even more than what a judge has sentenced them to, which is what is happening right now. HB 535, again, unanimously passed the House, is on to Senate Judiciary. It doesn't have any known opposition to it. As we try to fix that decision, that's really been damaging the lives of people who are impacted by it. So I know that was a very quick overview of four bills, but I'll put our information in the chat as well as my own email and contact information in case people want to reach out and learn more.
Thanks, Wade. And now, Graham, if you want to talk a little bit about House Bill 176.
Yeah, I can do so pretty quickly here. House Bill 176 does a handful of things, but was largely a result of I guess two Georgia Supreme Court cases that I won't go too far down the rabbit hole with, but very loosely there had been the long-standing ability for defendants to potentially have out of time appeals, like sort of in quotes, that within the Cook case in the Supreme Court, the court decided that they didn't actually have a legal basis for those, but as sometimes happens in a Supreme Court case, it was written very directly to the legislature to say, while we're not trying to act as the legislature, this can almost serve as a note that if the legislature wants to keep this process alive, they should write legislation to do so. This bill, I'm hoping, continues to move. It got all the way through both chambers last year through conference committee, and then a quote unquote problem with the printers sort of held it up on the very last day. So we're hoping that we're able to make it all the way all the way to places we did last time, and hopefully the printing situation at the Capitol. I say that a little bit sarcastically, is not quite so bad this time. But again, that is a good bill that again I think most people largely agree with. There's a little bit of testimony on the other side. However, that was a long-standing practice that we're hoping to put back into the code, officially into the code, I guess I should say.
Thanks for that. And the last good bill that crossover that we're going to discuss will be from Ray, House Bill 225.
Yes, thanks, Blake. So I would say that House Bill 225, which is a bill looking to address the speeding camera in school zone issue, which is very hot. This year has been hot for quite a while. I would say it is a halfway good bill, and it's halfway good in that it addresses part of the problem, right, which is another layer of excessive fines and fees that school zone speeding cameras create. However, the thing I want everybody to think about the most when we think about speeding camera and school zone issues is that the speeding issues we have in school zones, the root of that is because we have roads that are dangerous by design. Therefore, we must have solutions that address the design problems of roads to get to the root of speeding. With that said, House Bill 225 passed over, and is now crossed over into the Senate, into the Senate Public Safety Committee, where it looks like just completely get rid of cameras in school zones altogether, but may be a very difficult thing to pass because it doesn't address the issue in terms of what do we do now that the cameras aren't there in terms of the speeding issue that happened in school zones and the child and pedestrian safety issue that's still left unaddressed. So it hits on one part in that we don't want to see an added layer of fines and fees, which have disproportionate harms on Georgians who are at or below the economic margins. But we also must look at any speeding camera school zone issue as we have to address the issue of roads that are dangerous by design. So any solution must address road design. Anything that does not address that in terms of these child safety problems in school zones is not a full solution to be able to get to the root of it. So I'll stop there.
All right. Thank you, everybody. So again, all of these bills that we just discussed are bills that crossed over and are bills that we are glad crossed over, from reforming the death penalty statute for people with intellectual disability, safe storage, survivor justice, fines and fees, access to appeals. All of those 8 bills that we just discussed are good bills that have crossed over. So appreciate that, because the next now I'm going to ask people to talk about some of the bad bills that have crossed over and still need advocacy in opposition to them. Graham, if you want to kick us off in this section by discussing a handful of bad bills that are still in play.
Yeah, want to is probably not the phrase, but yeah, starting with SB 9 and HB 171, these are bills that are aimed at um, sort of enhanced penalties around crimes that have been committed slash enhanced by AI. They are very broad. The sponsor of the House version of this uh, gave testimony talking about, and this was not a example, but what happens if you get a call from someone asking for you to send the money very quickly and you hear an AI voice of a loved one in the background. It's as broadly as that. I think it could be something as broad as that. The main thing that they are looking for is sort of the use of AI to generate child pornography, I think is the key thing that we are looking at there. That bill, we sort of offered testimony on it and said that, that sort of scenario, we certainly understand. We wish that it was not so broad that it could potentially also affect 13 to 17-year-olds, high schoolers that are playing around with AI, in a sports locker room, putting something joking that could potentially have them become felons because there's not any sort of, we don't exactly want to use this language, but any sort of Romeo and Juliet style carve out where younger people don't necessarily go right up to the felony version of violation of this statute because of sort of the way that we don't necessarily understand AI so much. I think that the sponsors of both these bills think that the fact we don't understand AI so much is a reason to put harsher penalties behind it, which I can certainly understand some of their reasoning, but we are hoping that there would be some smaller carve outs there and have offered that language a few different times. We're hoping that it has a little bit more have a little bit more traction this time around, as I think one of the big themes that you start to see after crossover day is kind of the bickering between the House and the Senate. Taking out all the things that made the Senate's version the Senate's, taking things out that made the House versions the House. Sometimes I think literally having the bills swap in terms of content while their names stay the same on one side. One note that I do want to have there is that HB 171 was sent to I think we just saw this today, the Technology and Infrastructure Innovation Committee. Not exactly where you would expect this sort of bill, but for Representative Thomas, who's the sponsor of 171, is the vice chair of that particular committee. So not a committee that I'd imagine a lot of us are as used to appearing in front of in terms of some of the others, and we want to watch that piece closely there. I'll also talk, I guess, about the next two as well. House Bill 70, or I guess that's Senate Bill 79, the fentanyl bill. The goal here is again understandable. Fentanyl is a incredibly deadly drug, and as a result, the penalties for it are getting very, very harsh, both for um, uh, obviously for traffickers, for dealers, but also for users. I think our biggest concern here isn't the mandatory minimums that we are seeing, and potentially the overly harsh penalties for users. I think especially in committee, the bill sponsor would hold up you a sugar packet and say this is enough to kill X number of people. And it is obviously an extremely dangerous and potent drug. As a result, though, it's also a drug that I think many of us may have heard about in part because tiny parts of it are able to spike other drugs. While this makes it more dangerous, and I think even in committee we said we understand the desire here to punish the dealers that way. Users could get caught into this sentencing scheme without any intent of using fentanyl whatsoever. Also, just sort of the general issues that we have with mandatory minimums, the idea that, what we know about punishment is that people are more likely to change their behavior based on likelihood of being caught than ratcheting up the penalties. I think some of those regular pieces there. Again, one where I think both the House and the Senate, it seems like even immediately are looking for ways to toy with each other's bills here. The SB 79, again, a lieutenant governor bill, so it's been a little harder to make any sort of edits there whatsoever. The last one I'll say here is SB 204. this is a bill from Minority Leader Harold Jones the second. Essentially, the pitch here is that by making more crimes able to be accused as opposed to having to go through the indictment process and getting a grand jury, they can increase efficiency. There's the note that several states are already doing this kind of thing. I want to say Florida and Texas are the two that keep coming up where more things can be just accused as opposed to having to go through the indictment process. We're of the mindset that even if going through the grand jury process is often a little bit of a rubber stamp, the cases that aren't rubber stamped are pretty important. And even just the fact that a district attorney has to go through the process of putting a case together, even one that they feel very likely they will win, is valuable and lets people know what they should put before a grand jury and what they shouldn't put before a grand jury. The testimony that we've heard about this bill has often revolved around it being a poor use of police officers' time. The idea that they would have a shift from 7 to 7 and then have to go and appear before a grand jury as being a problem. In my mind, that sort of speaks to the fact that there may not be like quite the legal rationale that you would hope for if you were making this large a change to the process. So again, I think all three of those bills, ones to absolutely absolutely keep an eye on. I don't believe SB 204 has a House equivalent there. But again, I will certainly keep a watchful eye on all of those. Mostly those will be in various, I think, judiciary, non-civil, aside from, again, House Bill 171 sent to that technology, or SB 9, I guess, the equivalent sent to the Technology and Infrastructure Innovation Committee.
Thank you, Graham. I'm shocked to learn that harsh sentences for drugs doesn't eradicate drugs. I'm also shocked to learn that the state doesn't want to do its job by getting an indictment. But next, Coco, can you talk about a couple bad bills that are still in play and crossed over?
Yes. You will also be shocked to learn that sometimes in an attempt to solve a problem, there is often the use of a sledgehammer as opposed to a scalpel. And I think the next two bills I'm going to talk about are really good examples of that. And I think also too are really products again of like what has happened at Appalachian High School, but also very much sort of the uptick that we've seen a little bit in the crossover of immigration and the criminal justice world, but also the way that we are now seeing state legislatures like really tinker around with this idea of like, like redefining terrorism, right? So some really good examples is like last year we had a bill that wanted to include littering at a protest as like technically a form of like terrorism, right? So clearly that did not pass, but I do think it sort of is good to have that historical knowledge to know that these are very much like building blocks on each other, and what fails one year might come back as a smarter, more sort of salient bill, one that has some calmer talking points. And I think these two bills that I'm going to talk about are really good examples of that. The first one is SB 61, right? And so SB 61 does 5 distinct things, right? So it expands jurisdiction of superior courts over young people, right? Easiest way to put that is it creates more opportunities to treat children as adults when they're moving through the criminal legal system, right? The second is that it also creates some really specific school safety measures. It also defines terroristic act and terroristic threat, and then creates a set of penalties sort of based on that. It creates information sharing between courts and schools, and then there is some language in there about drills and training, again, for school safety. I really want us to focus on the portion about the bill granting superior courts jurisdiction over the offenses committed by children ages 13 to 17, right? One, because we all know that young people's brains are not fully developed, right? There's like new, science coming out every day that young people's brains don't fully develop till they're 25. If you're neurodivergent, your brain might not fully develop, all the way up till age 35, right? So we're still really learning about the way that young people's minds operates. And also we know that young people are, because of sort of like where they are at in their sort of growth cycle, we know that they are capable of great change, right? And so while we see the legislature trying to attempt to solve the problem of how do we stop school shootings, right? How do we ensure that people feel safer to enter into their schools? What they are doing essentially is they're adding these new offenses of like terroristic acts upon a school and then attempt or conspiracy to commit murder, rape, aggravated assault, and other severe crimes, right? So it really is a very tough on crime approach to juvenile justice, which has really been created as a means of rehabilitating young people and moving them away from the juvenile justice system. And so this is really a mechanism that just not only drags them into the adult legal system, but it makes it much harder for them to then exit, right? I think Graham brought up some really good points. Again, like young people's brains are not fully developed. If you've ever hung out with a young person, if you've raised a young person, you know that they do really questionable things, right? And it's really important that the way we ask for accountability from those young people is in proportion to that, right? Again, we don't need a sledgehammer, we need a scalpel. And so again, like right now, that bill is crossed over. It's currently sitting in Judiciary Non-Civil. The chairman of that committee is Tyler Paul Smith. Tyler Paul Smith tends to be really good about listening to concerns on bills like this. He's definitely been an advocate for some other pieces of criminal legal reform legislation. So I would say if he is your representative and or you just want to call him to air concerns about this bill, I think that would go a really long way, right? And again, messaging should just be like, we need to treat kids like kids. Like it's just point blank period, right? And then the second bill I'm going to talk about is SB 29. And so this is a DNA bill. And so what it does is it modifies the regulations surrounding DNA sampling, collection, and analysis in Georgia. And it really expands the conditions under which DNA is collected, emphasizing the inclusion of individuals arrested for felony offenses at the time of booking, right? So DNA samples, if this bill were to pass as currently written, DNA samples would now be collected from individuals arrested for any felony at the time of their booking or their processing at the detention facility, right? So previously, DNA was limited to those convicted or individuals charged under really specific circumstances, right? The bill, and this is going to start getting into some like technical stuff, right? And I feel like there's like the meat of the bill, which is really, really important. And the technical stuff is also like really crucial to know. But it's also, I know that that part can also like not feel as accessible sometimes. Like I am not a lawyer like many people in this panel. I certainly struggle with those details sometimes, but I do want to share these details because it feels really important for folks to know. So the bill does broaden the definition of detention facility to include any place where individuals accused, convicted, or adjudicated of violations are confined, whether that is young people and or adults. And then again, it goes into a bunch of very technical DNA exemptions, restrictions, and expungements of DNA, right? It creates like a 30-day time period where DNA can be collected. And if for some reason a case does not go through or is dropped, that DNA is expunged, right? But also that brings up a lot of questions about like, okay, well, who is expunging it? And like how, what does that mean to expunge it? It essentially moves from a post-conviction model to a pre-conviction framework. And it's being touted as this like really smart way to improve law enforcement's ability to solve crimes. But it is raising a lot of legal and ethical concerns, right? For like all sorts of reasons. And so that bill is currently in the Public Safety and Homeland Security Committee that is chaired by Clinton Crowe. Again, if he is your representative, I would strongly recommend giving him a call. You can also just call him if you want to talk to the chairman. Again, I do not have talking points right now for SB 29. I am working on those as we speak. But I think the biggest thing to know is that like it's like creating a legal ethical quagmire, right? And it's really testing the boundaries of like innocent until proven guilty. And so with that, I'll pause and I will turn it over to the next person.
Thank you, Coco. More shocking, more shocking information that children are in fact children, and should be treated as such. The last bill, that we're going to discuss, that is not good and House crossover is House Bill 651. And Ray, can you talk to us about that?
Yes, yes. So, House Bill 651, is a bill that swings all the way on the other side of the pendulum. It's the previous bill I talked about, they both deal with, again, speeding cameras in school zones. So the previous bill seeks to just get rid of all cameras altogether. This bill here, House Bill 651, ultimately will lead to a mass expansion of speeding cameras in school zones. So before I say anything else as far as the details of it, and I say this all the time now because this is the part that is not part of the conversation among lawmakers as of yet. What it must be is that streets, school zones have speeding problems because they are dangerous by design. Road design, road design, and road design. So any solution to address this root must deal with making streets safer so that they do not encourage speeding and that they proactively stop it before it even happens, right? So to go into the details of HB 651, which is going to lead to this mass expansion of speeding cameras, it seeks to, one, take away schools' authority to be able to even apply for cameras. And that's part of what can lead to this mass expansion because it gives that authority to law enforcement. And law enforcement, of course, has looked at speeding cameras as another revenue generator for excessive fines and fees. Along with that, it comes with a twist. Now, what makes it a little different from some other bills that have looked to create a mass expansion of speeding cameras schools is that it looks to have a twist in terms of how it divides up the revenue. So this bill would look to give half of the revenue to law enforcement and half of the revenue that will be split between law enforcement and camera companies that make these cameras. And the other half of that revenue will go to school districts. Now, this is why this part is bad, right? So, think about one school district, right? And the places where cameras are likely going to be put are the places that have the biggest speeding problems, which are the places that also have the worst road design. The places that have the worst road design are typically the places that have the least amount of investment in terms of having good roads. And what places typically have the least amount of investment? Yes, low-income communities, Black and brown communities. So you think of a school district where it's making the majority of its revenue off of perhaps the poorest part of that district who has cameras there that are going to be placed there to generate all this revenue, then it gets spread across that entire district. So the poorest communities within a school district are making the majority of the money, and that wealth is being taken out of their communities and spread across all other communities there, which is a disproportionate share of revenue that again would take wealth that is not being placed towards road design. It's being just given to law enforcement and camera companies. And that is not the way to address the root issue, which is road design. So keep that phrase. So in terms of talking to lawmakers, because Representative Adam Powell, he is a lawmaker that is trying to champion this bill. And any other lawmakers on the Senate and Senate Public Safety that are considering this bill, when we reach out to them, the first question should be with any speeding camera and school zone bill is, what are you going to do about road design to proactively address the root of this problem, which is dangerous design of streets and schools? So I'll stop there and I'll pass it along to the next.
Thank you, Ray, and thank you everyone for all of that information. Dense and important and timely information. We have a little bit less than 4 weeks left in the session where things like this could become law. So thank you for helping keep the JRP apprised of what's going on. Real quickly, as I discussed earlier, the majority of bills did not cross over. Lots of legislators don't like that certain bills didn't cross over and will try to transfer what that bill did into a bill that is living or a bill that survived crossover. So now I'm going to ask Coco and Graham to each discuss a bill that is bad that crossed over. And I was going to say before Wade had to jump if somebody wanted to ask in the Q&A anything with the GJP. But Wade dropped his email if anyone does have questions regarding any of the bills that he referred to, specifically the 4 that they have that are still viable bills. Shoot Wade an email. But now we're going to talk about bad bills that didn't cross over but could resurface and still be an issue. Coco, can you talk to us a little bit about House Bill 602?
Yeah, absolutely. I do fully expect some of this language to come back and be tacked on somehow. I'm not sure how that will look like. I try to make sure that my tinfoil hat is like at an appropriate level of paranoia, but I think we see a pattern over and over each year of language kind of being snuck on at the very last hour of time. So this bill, it was introduced, it was sponsored by Representative Tim Fleming. And so the TLDR version is that it was going to basically financially penalize students on college campuses for like protesting wrong. Whether that was through if they had basically been sort of reprimanded by the school and or if they got like a criminal offense popped, right? But there was a lot of language taken out. Just like as a pro tip, if you are a legislator who is going to introduce any sort of like anti-protest or like curbing protest bill, it's probably not the best idea to introduce it in a committee where the majority of folks in that committee did participate in like civil rights sit-ins. Just really good perspective, because they can tell you exactly like why it is that this bill violates all sorts of things like due process and First Amendment rights, right? So, but like onto the meat of the bill. So what it would have done is it would have established penalties in the form of financial aid restrictions, right? So Pell Grants, financial aid, student loans. So anything that is state sponsored. And so when it died, it only made sure that those restrictions applied to students who had been convicted of a criminal offense resulting from materially and substantially disruptive conduct on a college campus, right? It did try to have control over the administrative process for a school, and that was very much removed. I do feel like it's really important to just kind of talk about like the language that was introduced for that, because I think it is a little bit of a bellwether of like what we're going to continue see rising, especially as like more protests continue to happen on campus, right? And this very much does feel sort of like a response to what happened on Emory's campus regarding the Palestine protest. And so what this bill did was it defined campus as any building or ground owned or occupied by a higher ed institution. It clarified conviction to include guilty pleas, findings of guilt, as well as like first offender treatment. And it specified criminal offense as violation under Title 16. And then it established materially and substantially disruptive conduct to include an entire spectrum from physical violence to basically blocking access on a campus facility, right? So it just like an incredible wide spectrum of behaviors that could like fall under this. So just like leaving things very open to interpretation. And then the last but not least is that it did the thing where it exempted constitutionally protected speech from being classified as disruptive conduct. Also very confusing, wasn't sure how they were going to pull that off. But again, like I think the biggest thing is that it like brought up some serious First Amendment concerns, right? And then it also brought up some really serious due process issues, right? So like the automatic denial of financial aid upon conviction raises a lot of concerns about fairness, and especially if you have like a student going through an appeal process, right? So good news is that this bill did not, pass through crossover. Even better news is that there were Republican representatives who came and testified in the committee hearing and said that they did not like this bill, which is, good thing. The bad news is that like the legislature will always do what the legislature does and find an opportunity to add this type of language to some other bill, right? So ever vigilant usually is the best way to sort of go about these things. So with that, I'll pass it to Graham.
Yes, similarly, and I think this time of year when you start to see bill numbers in the 600s, you know that it has a long amount of space to travel in a short amount of time. And House Bill 675, because the House does not have the same regulations as the Senate in terms of when a bill has to be heard before it can be on the floor, was heard for the first time at 8 a.m. on crossover day. We were there along with a handful of other advocates to sort of look at some pretty troubling language, I would say. Essentially, this was attempting to criminalize material support for terrorism. It mostly mirrored a federal statute, but had taken away some of the key exceptions in the federal statute, which were attempted to be put back in by the committee. Amendments were being offered again. I guess what's the amount there? 16 hours before the absolute deadline that they would absolutely have to. This was a bill that was a bit of a mess, and so I think what's maybe more important is to think about the idea of it here. The language that actually came out of that committee, I'm still not sure if it matches the federal statute, and so there are issues of constitutionality all over the place, not just with the First Amendment, but also preemption, and if there is a state law that comes close to matching the federal law but doesn't, and you're talking about a crime of supporting terrorism in Georgia for a group of terrorist organizations that is named in the federal code. If you ever see a bill number that has ER at the top right corner, it means that the person drafting it has not completely understood all of the implications, or the legislator bringing it is a little bit all over the place and has maybe done some things that are just outright unconstitutional. It still was able to get out of committee even if there was a motion to table during that committee, just because it, I think, so obviously had work to do. And the bill's sponsor did go to the Rules Committee as it was meeting at one point to sort of personally ask them to put it on the rules calendar. So I think it probably is safe to say it's also sort of a Title 16 bill, crimes and offenses. There are going to be plenty of those as you start to look at potential routes. And my brain hasn't completely started working that way. I need to shift it into that mode in terms of what bill can now be a vehicle for that. But there's always the opportunity if you have, sort of like if they're in similar sections of the code, and there's certainly a lot of crimes and offenses, I have no doubt that that language will sort of be shopped around, and some equivalent may try to be stuck on somewhere. So that's a great place to sort of stay vigilant, and for everyone here to think, okay, we recognize this language from a very hectic crossover morning there.
All right. Thank y'all for those. And those, of course, aren't the only two bills that didn't cross over that we would care about. I don't know the feasibility or likelihood of any of the good bills that didn't cross over, us being able to, or whether it's a lot of member organizations' MO to try to zombie those. But whether we can do that, whether we do that or not, just because a bill didn't cross over this session doesn't mean this year doesn't mean that it won't be successful in the second year of the session. So if there's also if anybody has a good bill that comes to mind that didn't cross over that you want to talk about, I think Ray has one. I will pass it to him. But before I do that, if anyone has any questions, please drop them in the Q&A and we will try to get those addressed for you. But Ray, do you want to talk about House Bill 140?
Sure. So House Bill 140 is a bill that was a great bill, a bill that I have not seen come through the legislature since I have been into UPI, which would have put safeguards in terms of stopping cities from having an excessive and abusive reliance on fines and fees to fund their budgets. It would have capped their reliance on fines and fees revenue to fund their budget at 10%, meaning that no more than 10% of their budget could be filled with fines and fees revenue from like traffic tickets, court fines and fees, all of that sort, in terms of, particularly minor offenses that create revenue in various forms of fines and fees. So it would have capped that, which would have, had a positive effect in terms of stopping police from having quotas that where they're looking for people who not just looking for speeding offenses, but for stopping people and giving people tickets for broken taillights, other type of minor traffic offenses that they look to rely on and over enforce as a way to get revenue to fund their budgets and to fund city budgets. Unfortunately, that did not pass, but we hope that next year that there will be more, there will be a heavier push for that bill. Unfortunately, the speeding camera in school zones bills got so much of the attention that unfortunately there wasn't enough put on that bill in order to bring it to help it to cross over. But there was a lot of Republican support for that bill, particularly in the committee that it started from, which is the Government Affairs, House Government Affairs Committee. There were some Democrats that were reluctant about that, who had some reluctant thoughts about that bill. Unfortunately, at that time, they were listening to talking points that were being given to them by law enforcement and law enforcement supporting organizations such as at least supporting law enforcement in this situation, such as the Georgia Municipal Association, who sought to water down that bill or claim that putting this type of safeguard on reliance on excessive or abusive fines and fees practices would hurt the road enforcement task of law enforcement. It would not. But that was the framing that they tried to place on this, to say that it would harm cities' ability to raise revenue and harm law enforcement. And the last thing I'll say about that bill, of course, is that yes, when you reduce a revenue source such as fines and fees revenue, of course, there should be other proactive revenue sources that cities should be able to rely on, so they don't have to turn to excessive and abusive reliances on fines and fees. So we hope that next year, when this bill has another opportunity, that there'll be a conversation again about a renewed, strengthened conversation about the need to create safeguards so that cities cannot rely on this type of abusive type of revenue, but at the same time have other proactive revenue sources to keep them from even thinking about turning to this form of revenue from that source. So I'll stop there.
Thank you so much, Ray, and Coco, and Rosalind, and Graham, and someone tell Wade that I said thanks. That covers what we wanted and needed to address in this Talk Justice Tuesday. I don't see any other questions posted in the Q&A. So I'll let anyone, there's your opportunity for anyone who wants to add anything else. I will say, For our participants, thank you so much for being on for over an hour now. I'm gonna drop my email in the chat. If you have questions, concerns, comments about bills discussed or bills not discussed, relating to criminal law reform, please, don't hesitate, to reach out. But, any of our panelists, if you have anything else to add, go for it, open mic.
I'll mention one more thing. That one more thing. While it's not I mean, our lawmakers are considering our budget, the budget for state budget for fiscal year 2026. And one important thing that is not being discussed is that is our prison budget in terms of a specific thing. Obviously, more and more money is going to fund state prisons for all the other things. But at the same time, a little bit further within that is about prison health spending. Now, this upcoming Thursday, there's going to be, the Georgia Department of Corrections Commissioner Oliver is going to present the, prison budget, state prison budget to lawmakers to talk about that. But it would be a great thing, and I've been trying to push very hard for lawmakers to grill Oliver about the fact that they're increasing prison health spending in terms of prison health contracts, but they're doing nothing about addressing prison health access in terms of changing or getting rid of prison health copays. For anybody who knows about those who are incarcerated, while there may be a quote unquote doctor that is working inside of a prison or medical staff, oftentimes people cannot access that because they either cannot afford the copay or cannot afford the debt that gets placed on them if they can't pay a copay. This is something that lawmakers need to grill Department of Corrections about in terms of how we address this issue in our budget, particularly our prison budget and prison spending. So if, in terms of, this is going to be in the Senate, public safety, and I'll put it in the chat in terms of the actual subcommittee is going to be in, but it's going to be this Thursday at 1 p.m. I would welcome anyone to, reach out to lawmakers on that subcommittee and say, hey, grill them about why are you not addressing prison health copays, which maintain a barrier to those who are incarcerated to being able to have healthcare access. Thank you so much.
Thank you for adding that. I think that it's always interesting to me that conservatives love to gut the budgets of ineffective or inefficient government agencies, except for the Department of Corrections, which does a terrible job at its mission that always seems to get hundreds and hundreds of millions. Thank you so much, everyone, for joining us, for giving us your time, your expertise. I learned a lot. I hope that our attendees did too. If there's nothing else, I'll say get some rest because tomorrow's another day. Like I said, we only have a little bit less than 4 weeks where lawmakers can get sneaky and we have to attend committee hearings that we didn't even have on our radar because we have to, as Coco said, stay vigilant. So with that, I'll say thank you and good night. Bye, y'all. Take care.